Hello dear students, welcome to Devika's Commerce and Management Academy, Company Law. In Company Law, we are discussing about director. Who is the director, what is his qualification, disqualification, position of director, appointment of director, removal of director, rights and duties we have seen. Today we will see the liabilities of director. This is also one of the important topic. What are the liabilities of director? Director is having 4 types of liabilities. 4 types of liability. That is why he need to be very careful in performing his duties and rights. Okay. So, what are those 4 types of liabilities? The first liability is that liability to outsiders. Who is an outsider? Who is not involved in the organization? Sometimes maybe vendor, sometimes maybe outsider who is giving the loan or loan or any other amount. So outsiders, these are the people who are not directly involved into the organization. Not an employee of the organization, not a shareholder, not a director. So those people who are outsiders. So what kind of liabilities are there for the outsiders? The first one is that contract with ultravires. Ultravires means the company is having some bonds and some relations. So within that bonds and contracts, he has to make it. When he crosses that bonds, which is not in the hands of company, then it comes as ultravires. So there is a whenever he makes a contract with ultravires, means beyond the duties, beyond the responsibilities, then he will be liable to the outsider with whom he is making contract. These people can come to tomorrow and they can claim towards this company, and ultimately the director will become liable to the third party. He has to pay the damages. Sometimes it may become a court case also. So that is about the contract with ultravires. Next, negotiable instrument without company's name. Negotiable instruments means bills of exchange, writing a bill or promissory note. So that is without company's name. Whenever director is making any kind of transaction or contract, he has to take the name of the company. Without taking the name means it will become personally. If he is entering into any kind of negotiable instrument without company's name, then he will be liable. He will be liable to the third party because he is hiding the company. It will become personal. By taking the name of company, he is misusing it. It is personal. So that is why he will be liable in such cases to the third parties. Next one is that acting on their own name. Any kind of contracts or any kind of dealings, if they are acting on their own name, he will be liable. If it is personal, okay, let it be as personal. But company transactions with his own name means not allowed. Then he will be liable to the third party. Means he is deceiving the third party, right? Next one, wrong prospectus. Whenever he is representing a wrong prospectus means wrong information is given in the prospectus. Prospectus means which will be issued to the public. So there if he makes any mistake, public means third party. So he is giving a wrong prospectus. Definitely he will be liable to the public, to the third party for providing wrong prospectus, for providing wrong information, misleading the things, misusing the things. So that is why wrong prospectus, whenever he issues, he must be very careful. Something is gone wrong, then he must correct it and he has to issue. With the approval of director only, we are issuing the prospectus. He need to be very careful. Next one, committing fraud. Committing fraud, misusing the funds, concealing the facts and taking bribe, all these things are fraud. If he has committed any fraud, then he will be liable. In the same way, irregular allotment. Allotment also means shares allotment. Shares or debentures, as per the calls they have to allot it. That allotment should go smoothly and without any bias. It has to go through proper channel. If he is going to issue the shares with irregular allotment according to his wish, according to his personal benefit, if any irregular allotments are there, then also if it is proved, he will be liable for the act. In the same way, if court orders, personally director liable. Court orders personally. When will be the court orders the director personally liable? when something is gone wrong, if anything is proved, if anything is uh, revealed clearly that he made a mistake, he committed a fraud, he committed a misuse of funds or misuse of powers or any of such cases, court is going to say to the director he is liable. So this is also, if court orders personally, director is liable. This is all, everything comes under the third party, liability to outsiders. In the same way, liability to company, he will be liable to company also when few cases. For example, negligent towards their duties. If he is not performing his duties properly, negligence is there, then he will be liable to the company. Company is going to take action on him, company is going to find some amount, it depends on the case to case. So anyway, he will be liable if he is not going to perform the duties properly. In the same way, commit any illegal act. If he is going to commit any kind of illegal act which is not legal as per the company norms, then he will be liable to the company. In the same way, breach of trust or misfeasance. Breach of trust, company is trusting this person, company is giving rights and duties to perform to perform well, to take care of the company. If he breach the trust or misfeasance, then he will be liable to the company. Company can take action on them. So they can put any kind of cases on the director because of all these things. Next, the third one comes to liability to shareholders. Shareholders also. Company, the director become to the shareholders. Who are the shareholders? Means generally we call them as the owners of the company. These shareholders elected particular person as director on behalf of them to perform the duties properly. If he doesn't perform the duties properly, if he misuse the powers, if he misuse the things, then automatically shareholders have the power to liability, means these people, director will become liable to the shareholders also. When, in what cases? Especially breach of trust. Director is appointed by the shareholders with a trust that he is going to work on behalf of them. If that trust is broken, if there is a breach of the trust, then he will be liable to the shareholders. This is one point. Next thing you can say, fail to use reasonable care and skill. Reasonable care, generally whatever knowledge he is having, that he has to take care of the company. Reasonable care, and with his knowledge and skill he has to take care. If he is not taking a general reasonable care also, then he will become liable to the shareholders also. In any of such cases, the shareholders have the right to claim the damages. Any kind of damages they found, they can claim the damages from the directors. That is why directors should be very careful, otherwise he will be liable even to the shareholders also. And lastly, criminal liability. Criminal liability means depending on the case to case, sometimes he will become, he need to be a criminal liability, he has to pay the criminal amount also. The criminal liability, this is, for example, I am giving you here, prospectus containing false statement. Prospectus issued, na? That issued prospectus is containing a false statement. When it is proved that it is a false statement, it has gone to the case, that case has gone to the court, and court has given a simple verdict that he has to pay 10,000 fine and also 2 years imprisonment. 10,000 rupees fine and 2 years imprisonment. 2 years imprisonment and 10,000 fine means this is criminal only, right? So that is why. So in such cases, this is only some example I have taken. There are many more things which we can take it as example. So like in any of such cases, the director will become liable, criminal liability we call it. And a few cases you can take removal by court. Court may remove this director. So that is also comes under the criminal liability. Why the court is removing? For example, for non-cooperation with auditor. Non-cooperation with auditor means to the auditor a proper information is not given. Not giving proper information or concealing the facts, misusing the powers, or otherwise manipulation of accounts, any of such cases which comes under the non-cooperation to the auditor. If this is the case, definitely he will be liable. And also improper use of shares. Shares, whenever the company issues us, the shares amount is collected, means that shares amount is to be used properly. If at all improper use of shares, then he will be liable, means misusing the shares. And also failure in presenting balance sheet in annual general meeting. He is not presenting the balance sheet in annual general meeting, that is also liability, criminal liability it is called. When balance sheet is not presenting, then what he is maintaining and how he is maintaining the organization, that everything is minimum thing, na? So that is why in any of such cases we can say that it's a criminal liability. Take a screenshot or note down. Let me give you a recap. Liability of every director will be 4 types. One is that liability to outsiders who is not involved in the organization. So for those people we have discussed all these things. And liability to company, second one. And liability to shareholders, liability, criminal liability. 4 things. Just remember the main points, these 4. Liability to outsiders, liability to company, liability to shareholders, criminal liability. 4 points. A very important topic you may expect in the exam. So don't ignore it. Whenever you attend my class, immediately take out the textbook and read your material also. So this one and your material, the concept goes inside of the mind very clearly. Do recommend this channel to someone who is struggling to learn the subject, and keep in touch, study well, have a bright future. See you in another video with a good topic. Stay blessed, good luck.